Okay, guys. Like I said, most likely going to pre-service dismiss this here case that I filed. It's $405, but I'm going to keep working on the case, okay? My problem right now is that I can't finish learning because what they sent me, there's like 10 more books to read, okay? Because now not only do I got to worry about federal district court procedural rules, I got to follow procedural rules of specific judges as well. and I filed the case on Thursday, and yesterday I went and filed two motions. One, I wanted a motion for pre-delivery, pre-service motion for discovery, for our motion for pre-service discovery for purpose of John Doe identification. I filed that motion yesterday, and I filed a motion to have the clerk serve as process server by way of certified mail return receipt for the summons and the complaint. Okay. Now under Rule 45 for the pre-service discovery, that's under Rule 45, that will take subpoenas, okay? The subpoenas have to be hand-delivered by a process server. Now, I already knew all these rules because I had already been reading. One of the books that they told me I had to read was this one right here. This one right here in Cornell Law School. I've been reading the hell out that book. That's one of them they told me I got to read. Alright, guys, like I was saying before my camera ran out of memory, I had to delete some of it. I already knew what all this was, but there's so many more books that they say I need to read before I go to court. And guys, I filed this case on what was it, on Thursday of last week. Yesterday, Monday morning, I went and filed the motions that I described, and then by the time I got home, a couple hours went by and the mail came, and I had in the mailbox the letters that I got that y'all are going to see in this video. Okay, but yeah, but really my motion for pre-service discovery should buy me some time, but really I thought 90 days for service, and after service was made, this would be scheduled, this here meeting with the court for him to set as a timeline. No, the clerk scheduled my meeting and I had it ready in 2 days in the mail already, just that quick. It is what it is. So I might go ahead and dismiss this case, okay, so that I can refile it at a later date, because like I said, statute of limitations turns out to be 2 years, not 1 year like I thought. So I actually got to February 7th of next year to do it. But each one of these district courts, I done closed some of the tabs that I had open. See, this here's local rules. Like I said, I was just reading it all, okay? Okay. This is just one of them, man. There's like 10 different books I got to do, man. Okay? 10 different books that they say I got to read. And a couple of them were not there, okay? You see, I'm telling y'all, man, all of this stuff. But I don't have time, but I'm still working on what I need, okay? Right now, I'm trying to list what evidence I actually have, okay? I'm going to show y'all before I ask for evidence, and my motion to discover from them, what I was going to ask for them under Rule 45 and subpoenas. I want from UTMB and the police department, I want the entire disciplinary file on the police officers, every one of them involved, every one of them, okay? I want body cam footage from the incident involved. I want body cam footage from an incident that happened in Pacu a few months earlier. I want body cam footage from the night that cop that kicked me around over there searching me real rough came into ICU because I asked for a supervisor. I want that body cam footage, okay? There's no way at all possible that that cop that participated in my arrest, either Hernandez or Gonzalez, can say that he didn't know that Linda was my wife. There's no way at all possible McGee or Zermino can say she didn't know Linda was my wife. Okay, guys, I'm just going to, like I said, I might withdraw it right now, $405 extra it might cost me, and I might wait another 10, 11 months. By then I will have all the books read. I'll have all the motions and everything prepared to where I don't have to do no work at all. I just got to take my motion and file it as they file theirs, because I've been reading a lot about what they're fixing to try, all the dismissals they're going to try, and there's some where they try dismissals. I'll go on ahead and voluntarily dismiss some of my claims that may be frivolous, but they're not frivolous, but they're not constitutionally protected rights, okay? Turns out, based on what I've been reading, you do not have a constitutionally protected right to choose and pick medical care and who your doctor is going to be. You do not have a constitutionally protected right to choose a patient care advocate. And constitutional rights do not recognize God-given rights, okay? I'm telling y'all. And they don't, that's another thing, the words God-given rights, they don't like that. I mean, there's kidnapping, all these auditors using the word kidnapping and rather than unlawful seizure, kidnapping, assault, and things like that. When you're talking about cops, they hold that against you, okay? So I need to take all that wording out, but at any rate, I'm going to show y'all some of the evidence I got, okay? I got a copy of the original incident report. I got a sworn probable cause affidavit by Officer McGee Powell for the JP Court for the charge of disorderly conduct by language, okay? In rebuttal to number 1 and 2, I got a copy of the motion to dismiss criminal trespass written and submitted pro se by myself to the Galveston County Criminal Court. Understand me, I'm not going to perjure myself for bullshit, okay? Number 4, in rebuttal to items 1 and 2, a copy of the motion to dismiss disorderly conduct by language written and submitted pro se to Galveston County Justice, Peace to Court, J. Black Appel. Keeping in mind, no way will I perjure myself in lieu of a $393 fine, then pay an attorney $3,000 to take the trial based on testimony of actual events as they happened on 10/4/2024, as I listed them in said motion. Judge Blake Appel's a piece of garbage. He said it had nothing to do with the First Amendment under my motion to dismiss, but y'all fixing to learn with the evidence I have, it's 100% on the First Amendment, okay? State's motion to dismiss criminal trespass citing unable to prove beyond a reasonable doubt. I have this. JP Court motion to approve dismiss disorderly conduct citing prosecutorial discretion. I have this. Statement of fact in rebuttal to number 2, UTMB is a public institution. Its employees, clerk, nurses, doctors are state employees performing governmental functions. So the First Amendment purpose, they are state actors, just like police officers, teachers, or DMV staff. That matters because the government cannot criminalize protected speech directed at its own employees. In support of the legal evidence, clearly established law. Okay? Houston v. Hill, the First Amendment protects a significant amount of verbal criticism challenge directed at police officers. Chaplinsky versus New Hampshire, profanity, insults, and angry complaints are not fighting words unless they are direct, personal, face-to-face provocations likely to cause a reasonable person to strike back. State employees are expected to exercise restraint so the bar can be even higher. Cohen versus California. The court held that the government cannot criminalize profanity simply because it is offensive. One man's vulgarity is another's lyric. Hey, you ain't never met a motherfucker quite like me. Okay, this directly protects a citizen who uses profanity while complaining to a government employee. Okay? This directly protects a citizen who uses profanity while complaining to a government employee. Speech criticizing government services, court First Amendment activity. City versus Hill again. The court emphasized that citizens have the right to verbally oppose or challenge police actions. If police who faced with danger and confrontation must tolerate verbal criticism, then hospital clerks, nurses, and doctors certainly must as well. Virginia versus Black. A true threat requires a serious expression of intent to commit unlawful violence. Angry complaints, profanity, or statements such as "fuck you, you fucking pigs" are not true threats. Miller versus California, obscenity requires depiction of sexual contact. Patently offensive, lacking serious value, profanity is not obscenity under Miller. Letter from Houston Colorectal Surgeon Group stating Bobby J. Kennedy as sole caregiver and with significance and importance to be there to provide care for Linda Vine as needed around the clock. A photo of the unique ostomy wound showing why it required special care from one trained by a professional to give it, such as the way Bobby Kennedy was trained to care for said wound by the professional nurse practitioner Mary Hill of General Surgery Department U of UTMB. A complete list with a description of use on the materials and supplies it took to care for the wound to understand how bad the panic for Miss Linda Vine was while I was locked up in jail. A photo of the phone log showing the call from urology department directly to Bobby Kennedy 4 days prior to the appointment on 10/4/2024 to request him personally to bring his wife Linda Vine 2 hours early. So they called me on 9/31, I think it was, or yeah, 9/30 or 9/31, whatever, 4 days before that date. Okay, and I got a photo of the phone log showing that call. I got a photo of the phone log from the call on February 10th, 2024, 6 days after the alleged offenses fictitiously and maliciously charged to Bobby Kennedy by the defendants. From UTMB Urology Department, patient care advocate that Bobby Kennedy and Linda Vine was in the private office of when the police arrived. That video is posted on there on UTMB. Y'all can see that here too. A video and audio recording of said call mentioned in number 12 that has been posted to YouTube since the day it came in. See, a video and audio recording of said call mentioned in number 12. Number 14, there's a video of Officer Zermino from the day of the month of May where she had an interaction with Bobby Kennedy, fully acknowledging Linda Vine as his wife. Said video was and is posted to YouTube on May 17, 2024 under the title Officer Zermino PACU. Hey, go see that video. Huh? Y'all see that bitch? I hugged her when she first came in there, okay? And McGee Powell got jealous because I hugged her girlfriend. She was jealous. Okay, well, there will be a Q&A testimony from Bobby J. Kennedy as well, the opposition affidavit. And I got that for Linda, too. And I still got more evidence yet that I haven't listed. Like I said, I've just been working on this. I've been doing a lot of reading because I think I'm going to dismiss it and then refile it in about 10 months, another $405 out of pocket. But I'm 100% for sure that I can get the judgment. I'm also 100% for sure that there's no way at all possible they're going to even be able to think about coming after me for attorney fees, even if I was to lose. But, I don't want to lose. In order for me to win, I got to be able to follow their procedural rules to the letter, because these judges, they ain't going to give you no slack because they work for the state. So does the clerk. That's why I have a conference, a hearing already scheduled that I got to have the Rule 26F meeting conference paperwork filed with the court 10 days before it happens, and that meeting's happening 90 days from the time that I filed my complaint. I thought I had 90 days to service, and then I would have a hearing scheduled for this meeting 26F paperwork a few months later. No. So I'm probably going to have to kind of dismiss it, do a little bit more learning, make sure I'm 100% ready, because I know I can beat them. Okay, because if they refuse me the evidence that I'm asking for, all the body cam footage from every incident, including the ones that I listed there. I also want the body cam footage from them that night in ICU. I want the body cam footage from Detective Collins in ICU when he came and woke me up at 4:30 in the morning in my wife's hospital room, okay? Because my wife was violently assaulted by a nurse in there based on misinformation from a falsified medical record, which also is a falsified government document by one of them doctors who wanted to cover their ass for the mistakes they made. Okay? She was violently assaulted, which resulted in the unique ostomy wound. Okay? With that, guys, it's going to be like a 1 hour long video. Y'all ain't going to like it. Nobody's going to watch it, but here it is. Alright, guys, and like I was saying, my camera quit on me. I don't know why, but like I was saying, I got essentially an 8th grade education. If I can understand the fundamentals of these laws, the police sure can. Qualified immunity is gone. There is no qualified immunity. Y'all will see with the videos I'm going to mix with this where I'm showing y'all what I'm talking about. It was 100% retaliatory arrest with no probable cause, not just for the trespass, but there was no probable cause for the disorderly conduct by language as well. Remember this, guys. UTMB and all their employees, including the scheduling clerk, the nurses, and the doctors, they are all employees of the state. They are actors of the state. They are covered under the 11th Amendment. You cannot sue the entity. Sovereign immunity. Lawful redress is legal, including profanity. They cannot be the victims in a disorderly conduct when the lawful redress does not include threats, true threats, fighting words, or obscenity. Profanity and obscenity are not the same. Look up the definitions under what's already been decided by the Supreme Court. Again, I quit school in the 9th grade. I essentially got an 8th grade education. I can understand the fundamentals of these laws. The pigs can too. Also want to point out to y'all before I show y'all what I wrote on the other video, mixing with this one, because I had a breakdown this morning. I think I'm going to go ahead and dismiss the case because I actually got 2 years. I'm going to voluntarily dismiss this complaint. Give me another 8-9 months to learn, and I may refile it. By then, I might just let it go because I got so many more expenses on the table right now. And right now, I got probably about 16, 17,000, and I can't afford to pay 60,000 in lawyer fees to 3 cops because I don't know what I'm doing, don't know the rules of procedure. I've been doing a lot of learning over the last 3 months, and like I said, I thought that I could file this case and I would get 90 days to make service. And then after I make service, they would schedule a hearing for order for conference and disclosure of interested parties, okay? Before you have this hearing, 10 days before you have this hearing, you have to file with the court a discovery case management plan. After you have a meeting with the defendants under Rule 26F. I already knew all this, but I thought I had 90 days to make service. After the 90 days, I could make the service within the 90 days. After service, then they would schedule this. No, they scheduled this. I don't have time right now to learn all the rules of procedure because I thought I had another 2-3 months to prepare in learning, but I don't have time to do that. And get everything I need to do to schedule this meeting, force this meeting, have this meeting, and disclose the discovery plan with the court 10 days before the 90 days is up. So really got 80 days to do all that. Plus they sent me a lot of what I've already been reading. The Cornell University School of Law, I've been reading a lot of that. But they straight up told me in their correspondence here that, you know what, they will dismiss my case if I don't follow their rules 100% to the T, and if the case is dismissed before it goes to trial, attorney fees for the other ones will be assessed to me. That's under the law. I've been reading this already. I don't need to read no more to know that already, okay? So what I think I'm going to do, because I actually got 2 years, not 1, for the malicious prosecution. The retaliatory arrest, got 2 years for that already. But the malicious prosecution in the state law gives you 1 year. But federal law does not borrow from the malicious prosecution statute. It borrows from the personal injury statute, which is 2 years. Therefore, even with malicious prosecution under federal 1983, and it cost me $405 to file. I'm fixing to lose that $405 because I'm going to dismiss without prejudice so I can refile at a later date. Within those 2 years, I got till February 7th of next year, 1 day after the trespass was dismissed, to file malicious prosecution for the factitious charge of trespassing, which it was, and it was clearly established before they charged me with it that I was there on legitimate business. I can prove that 100%. Okay? And 2, the disorderly conduct. They, after the fact, an hour after the fact, solicited a complaint from either a scheduling clerk or a nurse from UTMB. Again, governmental officials. I did not use no profanity towards them. I used it towards the police. But I could have used profanity towards them and got away with it.